May it please this Honorable Court, Chief Justice and Justices. I am Jessica Rhodes, Lawyer Disciplinary Counsel for the Office of Disciplinary Counsel. I'm here today due to an objection I filed regarding the recommendation of the Hearing Panel Subcommittee in this matter. The Hearing Panel Subcommittee had recommended a 2-year suspension for Mr. Clifton, along with other additional sanctions, including supervised practice upon reinstatement, prior to reinstatement, that he be required to undergo an independent psychiatric evaluation to determine his fitness to practice law and follow any treatment protocol, take additional CLEs, and pay disciplinary costs. I request that this court disbar Mr. Clifton from the practice of law due to his misconduct in this case. I do not disagree with the factual findings of the Hearing Panel Subcommittee. All of those factual findings were what I suggested in my proposed findings of fact.
So you want us to annul based on the existing facts in the record?
Correct.
And what's been our policy on this type of thing in the past, or what have other states done?
I don't know that there's, well, first of all, you give substantial deference to the findings of fact by the Hearing Panel Subcommittee. It is the burden's on the attorney to say that such findings are not supported.
If we accept the facts in the record, give us the law that you rely on.
A respondent mother in an abuse and neglect case. The reason, and in that case, he was only suspended for 75 days, but I believe that's distinguishable from this case. This court found in the opinion for that case that there was no evidence of any of the sexual overtures beyond the attorney's denial of those. The victim in that case did not appear and testify at that hearing. In this case, there were 3 victims that appeared and testified to the sexual misconduct. The first victim, TNS, talked about that she was required to perform oral sex, provide explicit photos and videos to Mr. Clifton while he was an assistant prosecutor. KM testified that she had to perform or at least kiss his penis while she was in his office asking for information about her son's criminal case. And LC went to his prosecutor's office in the courthouse about being a victim of a crime. She was actually a defendant at that time, too, for a destruction of property case, and he inquired and received oral sex from her.
Did the hearing board say why they arrived at 2 years?
They quoted all the cases that I supported for disbarment, and they said based upon the fact that Mr. Clifton had a previous sexual relationship with both KM and LC, they pulled that down from 2 years. They did not cite any case law or any standards or anything as to why to go down from that. And continuing to answer your question, Justice Benjamin, there are 2 cases outside of West Virginia. The Caputo case out of Pennsylvania, that was a deputy district attorney. I think he was the chief deputy. He pled guilty to engaging in sexual misconduct with minors, which we don't have here, but I certainly allege, and I think we proved, that he engaged in criminal activity when he lied to both the FBI and the state police. And that attorney was disbarred from Pennsylvania. Some of the language in that talks about the high bar that prosecutors, people in these public offices set. Also, there's an unreported case out of Virginia in which an assistant Commonwealth attorney had sex with the defendant after she was indicted, and he had sex with her in his office, and he ended up being disbarred.
Why should we overrule the hearing board? You had your chance. Why should we overrule the hearing board? You had your chance to make your case.
Well, I believe that the factual findings, it is so egregious, this type of conduct. And when you look at the other cases around the country, the Pennsylvania.
Let me ask you why did you not make the argument? You can explain why, I guess. We've had cases involving magistrates who engaged in sexual misconduct, and the court took them off the bench, literally. in those situations. Why would that not be analogous?
It certainly would be analogous. I just didn't touch on those topics because of the assistant prosecutor. He's no longer an assistant prosecutor, but I think the conduct in his office at that time was egregious enough to be disbarred. And I think all of the cases cited in the hearing panel reports support disbarment, and they just went down to the 2 years. I'm not quite sure why they did that beyond this previous sexual relationship, but I don't think that matters because all of these women came to his office in the courthouse, the prosecutor's office, to seek help.
But the hearing panel heard that.
Yes.
And who were the three people on the panel?
Steve Nord, J.B. Akers, and Dr. Gross, Dr. Edward Gross.
Dr. Gross, down
Yes.
Hurricane?
He used to be at Marshall.
Yeah.
Yeah. And, I mean, there was issues with this previous sexual relationships. However, you know, these individuals talked about that they came into his office for help, and he starts prodding them for sexual activity. And if you read the transcript from the interaction where TNS wore the wire to his private attorney office, you can see how Mr. Clifton would keep pressuring, like, come on, just show it to me. Come on, just real quick. Please, quickly, come on, just real quick, just hold it for 5 minutes. That sort of supports what they testified in there about how he would keep pushing this until they did it. And it was obviously they were in a very vulnerable position.
Well, let me ask you this. If the reasoning was that they'd had prior sexual relationships with him, that seemed to me, and I'll ask Mr. McMillan the same thing, to carry more weight if we're in a situation where an attorney later, while representing the client in some capacity, has a relationship. But here, these were incidents where he had a different power base than these people did. They weren't on equal footing. They were, he was the an assistant prosecutor when
Yes.
these things occurred. And these women were all there in some official capacity as victim or defendant or checking on their son's case or...
Yes, and that's the issue, is even though they had these previous sexual contact, which I referenced and acknowledged, and I didn't have the issue, I didn't charge him with any violation of that in the past. However, once they are coming to him in his prosecutor's office, it makes it different because he does have a level of a power. And these previous contacts also occurred before he was an attorney. So not only does he have power as an attorney, he has even an elevated power as a prosecutor, which is referenced in the Caputo case out of Pennsylvania, talking about the heightened level that prosecutors have.
We understand your position.
All right.
Let's hear from Mr. McMillan.
Thank you, Your Honor. Mark McMillan for the respondent. Accompanying me here today is Aaron Snyder, who's also on brief, as well as the respondent, Gerald Clifton. Thank you for the opportunity to appear on behalf of Mr. Clifton today. And I'd like to first respond to some of the court's concerned. Apparently, we sort of begin this analysis with the presumption that the findings of fact of the subcommittee are well-founded. And in our responsive objections, we object to those findings, understanding that we do take on a significant burden. But to preface that, obviously the applicable standard of proof is clear and convincing evidence. As Ms. Rhodes alluded to, the primary accuser in this case is TNS, and everything else is just sort of 404B evidence related to that, emanating from people with whom the respondent had relationships with prior to his attending law school and so forth. But returning to the question of TNS, all of their witnesses and all of our witnesses, without exception, said that TNS was not believable. Beyond that, nearly every male that she associated with in connection with her presence in Pocahontas County was someone that she accused imposed their sexual will on, including the sheriff of the county, various other people. We produced witnesses.
Well, if TNS denied it, what evidence was there that TNS did this? that she performed oral sex on him, if she denied it.
Now, I'm not sure I understand the question, Justice Kennedy.
TNS deny that this happened in front of the hearing board?
No. And I'm sorry if I've caused you to misunderstand. No, she testified before the hearing board that the sexual relationship took place, although she's not straight on how many times that it may have happened, and her prior statements, depositions, and so forth are radically inconsistent and contradictory. But
Did the hearing board say she wasn't credible?
no, they credit her testimony within their findings of facts.
Now, that was the lady that was on probation at the time,
She was on day report.
and well, she wasn't in jail. She was on day report.
Yes, Your Honor. And
He admitted that he exchanged some sexually evocative photographs with her, didn't he?
well, an exchange may be a slight misnomer because the photographs all flowed from her to him. There was a single image of him that made it to her, but so to that
A
extent.
single image? Was
Yeah.
it a sexual type image?
Yes.
Okay, so it didn't all flow from her to him then. Let's
Right.
be honest.
No. I mean, there was.
Was this while he was an assistant prosecutor?
That's correct, Your Honor.
Why did the hearing board give 2 years?
I'm sorry, Your Honor.
I asked your adversary why they gave 2 years. Why do you feel they gave 2 years?
Well, I honestly can't think for them, Your Honor, but I read the same decision order or recommended decision that you did. But having listened to the evidence and actually represented the respondent below, while it's not reflected in their decision, I think the evidence was awfully thin, and that they came to, at least in terms of direction of the sanctions, they're in the right direction. We feel like they're a little strong given the actual misconduct, but
Did
never.
you cross-examine all 3 of the alleged victims?
I did, Your Honor. Point in time, because it would mean that the respondent was either an assistant prosecuting attorney or a private attorney, or perhaps neither. And when pressed on that point, as I indicate in my brief, she could not identify, though she might try, she couldn't identify in time when that may have occurred.
But did she say where it occurred?
Yes, she said that she believed it occurred. I better not answer that because I can't recall specifically.
Well, what's your best estimate? What did she say where it occurred?
I think she said in the courthouse, but my brief will be the better record of that.
Was his private office in the courthouse too?
Well, he was a part-time prosecutor, but he maintained an office in the courthouse, and much of this activity is alleged to have occurred there.
What my question? I'm just trying to clear it up. I mean, did he have a private office outside the courthouse, or do he do like part-time prosecutors in my county, and they conduct everything out of their assistant's office? For much of the alleged conduct, Your Honor, it was directly in the courthouse. He did have a second office, and later, when some of this is alleged occurred, it was exclusively in his private office.
Well, don't you think it makes a difference whether things occurred in a prosecutorial office or even in a private office if he was an assistant prosecuting attorney versus just a regular lawyer? Absolutely, Your Honor. That's why we acknowledge that that which we believe is either acknowledged or proved, and we assert that he has acknowledged his misgivings honestly and openly to his considerable embarrassment and otherwise. But if he's acknowledging these things, then why shouldn't he have a more severe punishment like other lawyers have had for similar deeds? Well, now, here's where we differ, Your Honor. He denies that he had these physical sexual relations. He acknowledged the business about the images and inappropriate conversations.
It's hard to deny that.
Pardon?
It's hard to deny that when the images are produced.
Well, sure. And
Wanting us to overrule their findings of fact.
Indeed. Indeed we do, particularly with respect to these compelled sexual relationships. He denies they happened, and the evidence is not only...
Well, if they didn't happen, then he shouldn't have any sanction at all?
No, that's not correct, Your Honor. That's not my point at all. he did things that are in violation of Rule 8.4, and there are sanctions due and owing.
Well, what are they? Because you said he didn't have any sexual contact with any of these women.
Well, no, we believe and we acknowledge that the exchange of these messages, inappropriate contacts and so forth, are the subject of sanctions, including reprimands, additional training, counseling, CLEs, even supervised practice, and perhaps even a short suspension. But disbarment would not represent the decisions, the past decisions of this court, and would not instill confidence in the legal profession. I believe it would detract from it.
He didn't contest the 2-year suspension, did he?
Well, we filed exceptions, not because that we felt like the 2 years was completely inappropriate. We do think it's a bit harsh, but we just disagree with some of the facts. For example, he's said to have lied to the FBI and to the police. Now, they originally...
Who lied to the FBI?
The respondent.
TNS?
No, the respondent. One of the charges is that he lied during the investigation, but during their live testimony in the hearing, particularly FBI agent Aldridge, upon review of his notes, said, well, it turns out he didn't lie. I'm looking at my notes and he didn't lie. So
What?
about some statements he'd made with respect to his relationship with TNS. And these are the same officers that brought the original charges, but then as they completed their investigation, they went to the prosecutor and went to the court and said, it turns out this woman is just not believable, and that's what happened.
But did they investigate the other two?
No, they had taken statements from them as 404B witnesses in their criminal case, but...
Well, did the United States prosecute him?
That he was never prosecuted, but anyway, this whole thing came as a self-report to an indictment in state court that ultimately was dismissed by Judge Henning, who, those of you know Judge Henning, he's extremely conservative and mean in ways of sexual assault matters, but the matter was dismissed with prejudice based on the lack of credibility of TNS.
All right, I think we understand your position then. Unless you have something you haven't added, we'll hear from the other side.
Everything else is in my brief, and I'm sure it's all been thoroughly considered. Thank you very much.
Thank you.
If I may address just a few additional comments. Just to clear up one thing, TNS was on day report and probation when the alleged oral sex happened, along with the exchanging of the sexually explicit photos and videos with Mr. Clifton, and he was the assistant prosecutor during that time. And again, as I recited earlier, if you look at that transcript between Mr. Clifton and TNS, which was well after he was no longer the assistant prosecutor, there's certainly a familiarity that Mr. Clifton has with TNS about touching her body and showing things, not going all the way, he said.
Is it probative that Judge Henning dismissed the indictment against him?
Under our rules of 8.4b states that it's misconduct for an attorney to commit a crime. It's not that they're convicted of it. We believe that we've met that standard.
It's a crime, but he wasn't indicted?